Hello, and welcome to another of our short teaching videos. My name is George Dunn, and I'm the Chief Executive of the Tenant Farmers Association. And this teaching is part of a series which shines a spotlight on topical issues being faced by the tenanted sector of agriculture. It's part of a growing YouTube library, which also features our webinars and important industry updates. Now, don't forget to let us know your thoughts in the comments below. And if you found this video useful, why not subscribe to our channel so that you don't miss out on any new content as we produce it. Today, we're going to hear from Caroline Squire, who's one of our expert rural surveyors here at the TFA, and she will be highlighting the risks involved in oral tenancies. But before we start, I'd just like to say that we're delighted that Roy Thorne's solicitors are sponsoring our 2025 virtual teaching sessions. Now, those of you who don't know, Roy Thorne's is a national firm of solicitors steeped in agriculture. They have over 90 years experience advising tenants and landowners, and their lawyers are also active in farm policy tenancy forums, so they do get the bigger picture. So whether you've got a succession application under the Agricultural Holdings Act or a new farm business tenancy, a dispute with your landlord over repairs, a share farming agreement, or a collaborative natural capital agreement, Roy Thorne's is there to advise and assist. So moving on to today, on understanding the risks involved with oral tenancies, what I should say is we're recording this in the summer of 2025, so everything we cover today is correct at the time of recording. So for advice on your individual circumstances, we do recommend that you call TFA head office and ask to speak to one of our team of advisors. So I'd like to introduce you now to Caroline Squire, who, as I said, is one of our specialist rural surveyors here at the TFA. So welcome, Caroline. The floor is yours.
Thank you very much, George. So a tenancy doesn't necessarily need to be in writing in order for it to genuinely exist. And oral tenancies are actually much more common than you might think. The key to there genuinely being a tenancy is that rent has been paid and the tenant has had exclusive occupation of the holding, and also that there's a noticeable intention for the parties to have created an agreement. Provided these criteria are met, it would be possible to claim an oral tenancy, even if there is nothing agreed in writing at all. It will depend on the date the rent payments and exclusive occupation commenced as to whether the oral tenancy has the protection of the Agricultural Holdings Act or whether the oral tenancy is a farm business tenancy governed by the Agricultural Tenancies Act. In order for the occupation to be an AHA tenancy, occupation must have begun prior to the 1st of September 1995, which is the date the Agricultural Tenancies Act took force. Given that the Agricultural Holdings Act gives the tenant significant protection, for example, by there only being limited circumstances a landlord can serve a notice to quit, an AHA potentially offers lifetime security for a tenant and possibly also succession rights if the occupation commenced prior to the 12th of July 1984. It can therefore often be a very acrimonious matter when a tenant is trying to argue that their occupation commenced prior to the 1st of September 1995, given the protection afforded to them under the Agricultural Holdings Act and the difficulty the landlord would have in removing them. It's a matter for the court to determine whether a tenancy is in existence or not. And if the tenant is trying to claim the existence of a tenancy, it's on the tenant to prove that they have a tenancy and that their occupation started on a certain date, rather than for the landlord to disprove the same. So the more evidence the tenant has to substantiate their claim for a tenancy, the better. For example, this could be check stubs or bank statements dating back to the date occupation commenced, showing that a rent has been paid throughout. It could be witness statements, which corroborate that the tenant has been in occupation since a certain date and that has been continuous. Or it could be IACS or BPS claims showing that the tenant was in occupation. If the oral tenancy commenced prior to the 1st of September 1995, meaning it's a tenancy governed by the Agricultural Holdings Act, both parties have the right to serve a Section 6 notice on the other, which requests that the terms of the tenancy will be reduced to writing. When being served by the landlord to the tenant, a Section 6 notice will prohibit the tenant from assigning, subletting, or parting with possession any part of the holding going forward from the date of the Section 6 notice. Hence, if a Section 6 notice has not been served on the tenant, it would be important to consider potentially assigning the tenancy, perhaps to multiple individuals, maybe including the next generation, or even to a company, in order to give the tenant even better security of tenure. If a Section 6 notice is served by either party requiring the tenancy to be reduced to writing, there's no time limit for the parties to enter into a written agreement, and if no agreement is forthcoming, the party who served the Section 6 notice can refer the matter to arbitration. An arbitrator would only reduce the terms of the tenancy to writing based on Schedule 1 of the Agricultural Holdings Act, plus anything else which has clearly been agreed between the parties. And Schedule 1 is a list of 9 very basic terms, including things like the names of the parties, a description of the holding, and the rent. If the oral tenancy commenced after the 1st of September 1995, then it would be a rolling farm business tenancy with no fixed term. Either party can serve notice to quit at any time, and the notice period will align with the rental payment frequency. So if rent is being paid every 3 months, then only 3 months' notice is required to end the tenancy. An oral FBT, therefore, doesn't offer particularly good security to the tenant. And for anyone in that circumstance, it would be very wise to try and negotiate a written agreement which gives the tenant a guaranteed fixed term and therefore some security.
Caroline, thanks for that. That's really, really interesting. Can I just ask a few questions which I think members and others will find helpful? So, in the circumstances of a tenant having an oral AHA agreement governed by the Agricultural Holdings Act 1986, and they did assign it after the landlord had served what you referred to as a Section 6 notice, would that be considered a breach of the tenancy agreement?
So if a tenant assigned their oral tenancy after the landlord had served a Section 6 notice, which of course prohibits assignment, rather than it being a breach, the assignment would just be considered void. It would therefore not be fatal to assign a tenancy after a Section 6 notice had been served by the landlord, in the sense that the landlord couldn't then serve a KC notice to quit it. But the assignment would be rendered void, so there'd be no point in assigning the tenancy after the service of a Section 6 notice, because it would incur numerous costs for something which would be considered void anyway.
And in the context of an oral agreement, who would be responsible for repairs?
So if it's an oral AHA tenancy, the 2015 model clauses for agriculture will apply in respect of splitting out the repairing responsibilities between the parties, as the model clauses are incorporated into every contract of tenancy governed by the Agricultural Holdings Act, unless there is a written tenancy agreement setting out the repairs differently. So if there's no written agreement, then the model clauses will apply in full. The model clauses, however, aren't legally incorporated into farm business tenancies in the same way. So if it's an oral FBT and there's nothing agreed in writing between the parties in respect of repairs and maintenance, then legally neither party is responsible for any repairs or maintenance.
And just in case we have people in Wales, there's a separate set of regulations for model clauses in Wales, isn't there?
Yes, the 2019 regulations, which are very, very similar to the 2015 model clauses for England.
And if, having served a Section 6 notice, the landlord then goes on to prepare a really thorough and lengthy tenancy agreement for the tenant to sign, is the tenant able to refuse to sign that?
Quite simply, yes, they can refuse to sign. As the legal fallback is pursuing the matter of a written agreement through arbitration, and the arbitrator would only set a basic agreement based on Schedule 1 terms of the Agricultural Holdings Act, if the tenant is presented with a really lengthy agreement which goes above and beyond the terms of Schedule 1, it would be wise not to sign that if it's more onerous and restrictive than the terms of Schedule 1. And the landlord would have no legal recourse to make a tenant sign such an agreement.
Caroline, that's great. Thanks for your time today. We'll have to leave things there for now. But if you do have more questions around your individual circumstances and you're not yet a member of the TFA, why don't you consider joining? Currently, membership starts from just £299 per year, so it is excellent value for money. And it gives you access to dedicated advice, information, and support from experts just like Caroline. So for more information about the TFA and how we can support all farmers in England and Wales who don't own the land that they operate, why don't you visit our website, www.tfa.org.uk, and there you'll find information about our upcoming calendar of events, as well as all the latest news affecting your sector. So we hope that you have found this little video helpful, and if you're watching on YouTube, it is part of our growing YouTube channel of information that you can access. So let us know in the comments below what you thought about this short video and any other questions that you've got. Don't forget to like and subscribe to our channel so that you don't miss out on other new content as we post it. Many thanks again to Roy Thorns for sponsoring our virtual program and to Caroline for today's content. All the very best and goodbye.